Alright, this is going to be my last video for the day. This gentleman, we're still in the Olmos Park video. This gentleman says the Olmos Park PD is corrupt, the chief is unqualified. I don't know why you put quotes around chief. He committed, in all caps, an aggravated battery yesterday, and trying to cover for him will not change that. He swore an oath to the Constitution, attacking people and assaulting them for not breaking the laws and not his job. So, not knowing exactly what he's going on about, I say the police are justified in using force to effect arrest if they reasonably believe the force is necessary. I haven't seen a video where the police chief assaults anyone, so I can't opine on his actions. You don't understand what the Constitution means, so stop braying about it. So braying about it means nothing. I address the Texas Constitution in the video. There is no aggravated battery in the Texas Penal Code, so I'll take your legal advice with the requisite grain of salt. Thanks for watching. Keep licking those boots, he says. This police department is corrupt. What evidence do you have the police department is corrupt? Just stating it means nothing. You may not like the law they're enforcing. I don't like the law they're enforcing, but that doesn't make them corrupt. Until that law has been in a court ruled to be preempted or unconstitutional, then they're not doing anything wrong by enforcing it. That's what they're supposed to be doing. So then he gives me this video to watch. Tell me again how these are such great law enforcement officers. These are thugs with guns and badges. I never said that any of these officers are great. I don't like the way they acted. I think they escalated a situation when they should have de-escalated it, but alright. So this is the video he links. This is News Now Houston. Yes, I've watched it. This one starts off after the arrest has been made. This guy right here, who's standing here, is the police chief. He doesn't do anything in this video, so I'm not sure entirely what this is going on about. I don't know what. So yeah, absolutely nothing happens in here. The police chief doesn't assault anybody. The police officer effecting the arrest has the right to make the arrest. He's not violent. I think maybe what you were actually looking for was something from this clip. This was from Black Label Cop Watch, and we actually see the arrest of the guy who got bonked on his head here. So he just said yes, he is the police chief. And I looked up a picture of this guy, the police chief of Olmos Park, and it does look like this guy. So he has a taser out. That is not a deadly weapon. And he doesn't discharge it, and he doesn't touch anybody. This is not the police chief. I have no idea why he's standing like that. This guy is about as dumb as he is fit. I mean, look at this guy. I mean, phew. How many donuts a day do you think this dude eats? Alright, so police chief doesn't assault anybody. I'm sorry, he doesn't assault anybody. Where was I? So I have no idea what this guy, Bill Stout, sells cars. I have no idea what this guy's smoking. The chief did not commit an aggravated battery. But let's go into it. Alright, so we have assault. This is what it would be. A person commits an assault if the person intentionally, knowingly, or recklessly causes bodily injury to another, including the person's spouse, or intentionally or knowingly causes physical contact with another when the person knows or should reasonably believe that that other will regard the contact as offensive and provocative. Aggravated assault. A person commits an offense if the person commits an assault as defined in section what we just read, and the person causes serious bodily injury to another, including the person's spouse, or uses or exhibits a deadly weapon during the commission of the assault. All right, so we don't have serious bodily injury. Yeah, the guy got the cut on the head. I know you want to say it's serious, but court cases will determine what is or isn't serious, and having to have a Band-Aid or a bandage applied doesn't make it serious. If this is going to be something like broken bones or stab wounds or something like that, it's not going to be a bruise or a cut. So, and then the deadly weapon, the taser wasn't a deadly weapon. The other officer with the looked like an AR-15 or maybe some M4. I don't know exactly. Might even be one of those nice HKs. So let's find Tubby again. So he does not have, the chief doesn't have a deadly weapon out. That's a less than lethal weapon. So he's got some sort of a rifle out. So you could argue that this guy better fits the aggravated assault charge. But if we go back up to just straight up assault, if he causes bodily injury, it doesn't have to be grievous. That would suffice, as long as it's intentional, knowingly or recklessly. And yeah, taking someone down to the ground physically would be intentionally, knowingly, or recklessly. So now we know that it would fit the base crime, but then we look at general principles of criminal responsibility, and we are going to actually look at law enforcement officers. Law enforcement. All right, so arrest and search a peace officer, and Texas statutes to define police officers as peace officers, or a person acting in a peace officer's presence and at his direction is justified in using force against another when and to the degree the actor reasonably believes the force is immediately necessary to make or assist in making an arrest or search, or to prevent or assist in preventing escape after arrest. If, and it's going to go on. So you're going to have to convince a finder of fact, that would be a judge or jury, that the officer was unreasonable in his belief that force would be necessary. And if we watch, he's giving commands. He says turn around. He's displaying his handcuffs. Get on the ground, and then he brings him down by force. So I think it is reasonable to believe that that officer would not have been able to effectuate that arrest without using force. But then it says if the actor reasonably believes the arrest or search is lawful. So the actor has to reasonably believe the arrest or search is lawful. Again, that's a question for the finder of fact. You would have to show, that's presumably it would go to something like the court would have to show that the officer knew or unreasonably believed that the arrest was lawful. So if the officer was making the arrest simply for the open carry, which is probably legal if the officer has no reason to suspect the gun is loaded, he just wants to arrest him just on open carry, that would probably be an unlawful, because he would not reasonably believe it to be lawful. But in this case, I have no reason to believe that the officers don't reasonably believe the arrest is lawful. Yes, I have already stated that ordinance is most likely preempted by the state statute. But that doesn't mean that the officer would not reasonably believe that the arrest is lawful. So then, they don't establish, they don't list a rule for lawful, but unlawful means criminal or tortious or both, and includes what would be criminal or tortious, but for defense not amounting to justification or privilege. Criminal would be the criminal stat. Tortious, I don't think it's gonna be tortious, and we'll go into that. But we just saw that there was justification, which means it's not criminal, because it's a defense that amounts to justification, and it has to not amount to justification to be unlawful. And then privilege is the tort, and I can't find anything on it, but typically there is the police officers are privileged to use force in the making of arrests. And then there's also this is a Supreme Court of Texas case. It's Thorster v. Tennell, and in this case they go over the immunity of the officer. This officer injured a suspect during arrest, and they laid it out. Official immunities of an affirmative defense that shields government employees from personal liabilities, so they are encouraged to vigorously perform their duties. In Chambers, we considered in some detail official immunity's good faith element. So what this case held is basically that if they're committing a discretionary act, let's see if I could actually find the language of it. But if they're doing a discretionary act, which arrest would be, there we go, the performance of discretionary duties, and they're within the scope of the employee's authority, and yes, it is in the scope of the police officer's authority to arrest people for committing misdemeanors, which that statute did make having a loaded firearm a misdemeanor, provided the employee acts in good faith. So good faith means that they believe it. They honestly believe that what they're doing is the right thing. It's essentially restating what this was. Reasonably believes that the search is lawful. So there was no, in summary, there was no aggravated battery, because there's no such thing in Texas as an aggravated battery. There's no evidence the chief is unqualified. The chief did not commit, that I could see, an aggravated battery. It did not appear that the chief committed any assaults or batteries. He did swear an oath to the Constitution, most likely. I know when I became a lawyer, I swore an oath to the Constitution of the state that I am certified to practice in, and to the Constitution of the United States. And it is a correct statement of fact that attacking people and assaulting them for not breaking the law is not his job. That is correct. But no one's guilty when he arrests them. They're only guilty after they've been proven to be guilty in a court of law. It's that whole innocent till proven guilty thing. So I don't know really how far you're going to go on that. So I hope this kind of illuminates things. I'm not trying to say that the police chief was right. I still think that this whole situation was handled wrong. I think they should have petitioned the town council, the city council, to change the law first before they started protesting. I'm not saying that they were wrong to protest. I just think that as a matter of getting things done in a way that is less likely to get people shot or hurt, they should have started there, and then if their pleas to the town or city council were rejected, then go to protesting. Because the protest is really designed to get you into court, get you arrested, get you into court. So there's a case or controversy in front of the court, so they could then adjudicate on whether or not that statute is or that ordinance is valid under the Texas Constitution, the Texas statutes, and maybe even the U.S. Constitution. So, but I'm not trying to defend the police. I'm just saying that it's their job to enforce the law, not to interpret it. And people going around saying that the law is unconstitutional on its face or whatever. It's the police can't just decide what is or isn't constitutional on their own. That's just outside of their scope. I've rambled long enough. Have a great night.